The family of 31-year-old Harish Rana had sought to withdraw life-sustaining treatment for him. To what end? To end his life. On 15th of January, the Supreme Court reserved its judgment on the plea. Why would parents ask euthanasia for their own son? What does Indian law say about such cases? Let's break it down in this edition of Explained. First, the case. Born in Delhi, Harish Rana was pursuing B.Tech degree at Punjab University in Chandigarh. In 2013, he fell from the 4th floor of a hostel. He has been in coma and completely paralyzed ever since. Now Harish cannot speak, move or feel anything. His parents, Nirmala and Ashok Rana, take care of him. After nearly 13 years of being bedridden, his conditions continue to deteriorate. Doctors have said that Harish's brain nerves have dried up and recovery is next to impossible. Harish suffers from quadriplegia, meaning he depends entirely on feeding tube and ventilator. His treatment cost from 25 to 30,000 per month. The family sold their house in Delhi's Dwarka and now live in a small flat in Ghaziabad. Ashok survives on a pension of 3,600 rupees and by selling sandwiches on weekends. Because of this mental and financial exhaustion, his parents have asked the Supreme Court to allow euthanasia so that he can die peacefully. Before getting to the timeline of the case and what was argued in the court, let's understand what does Indian law say about euthanasia. In 2005, an NGO called Common Cause filed a petition in the Supreme Court seeking the right to passive euthanasia. After prolonged hearings, on 9th March 2018, a 5-judge bench led by then Chief Justice Deepak Mishra gave legal recognition to passive euthanasia. The court said, if a patient is suffering from an incurable disease and is surviving only of life support systems, treatment can be withdrawn to allow a natural death. This will not be considered euthanasia, but the right to die with dignity. The court ruled that this right falls under Article 21 of the Constitution, which includes the right to live and die with dignity. How passive euthanasia can be implemented? First, when a patient has already written a living will. This applies when a mentally fit person voluntarily writes a living will stating that if their illness becomes incurable, they should be removed from life support. Only a healthy person above 18 years of age can write a living will, which must be verified by a judicial magistrate. If such a situation arises, approvals are required from the treating doctors, the hospital's medical board, and an
For more such videos, download Bhaskar English app.